This matter concerns the constitutional validity of Section 11 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act. This provision allows the Speaker of the National Assembly or Chairperson of the National Council of Provinces to direct the security services to arrest and remove a person creating or taking part in a disturbance within the parliamentary precinct. On 12 February 2015, whilst the President was delivering the State of the Nation address in Parliament, a member of the Economic Freedom Fighters inquired when the President was going to pay a portion of money spent on security upgrades at his Nkandla private residence in accordance with findings by the Public Protector. The Speaker responded that the State of the Nation address was not the occasion for raising questions of that nature. Dissatisfied with this, members of the EFF continued to raise the issue, refusing to accede to a request by the Speaker to leave the chamber. All the while, the President's address had come to a complete halt. The Speaker directed police officials to remove the members of the EFF from the chamber in terms of Section 11. When members of the applicant, the Democratic Alliance, learned that it was police officers that had removed the EFF members, their leader expressed the view that this action was unconstitutional, and the DA members walked out of Parliament. The DA filed an application in the Western Cape Division of the High Court challenging the constitutional validity of Section 11 of the Act on the ground that it was incompatible with a member of Parliament's constitutional privilege of free speech and immunity from arrest. Furthermore, the DA contended that the section violated the principle of separation of powers by empowering the Speaker or Chairperson who are part of the legislature to order members of the security forces who fall under the executive arm of state to arrest members of Parliament during parliamentary proceedings. The High Court held that Section 11 was constitutionally invalid to the extent that it authorized the arrest of a member for conduct that was protected by the immunity against arrest and the privilege protecting parliamentary free speech entrenched in Sections 58(1) and 71(1) of the Constitution. It did not rule on whether Section 11 violated the principle of separation of powers. Before this court, the DA seeks confirmation of the High Court's order. It is also appealing against the remedy ordered by the High Court, as well as that court's decision not to address the separation of powers issue. The respondents, namely the Speaker, the Chairperson, and the Government of the Republic of South Africa, are appealing against the judgment and order of the High Court. They argue that Section 11 does not infringe a member's constitutional privilege of free speech and immunity against arrest, but instead prohibits conduct or speech by members which stops or threatens to stop parliamentary proceedings. In their view, this type of conduct and speech is not protected by the Constitution. Additionally, they argue that the provision does not offend the doctrine of separation of powers. I have penned a judgment which is supported by the majority. Moseneke, DCJ, Cameron J, Khampepe J, Vandervershazen J, and Zondo J concur in it. The majority judgment notes that the privilege of parliamentary free speech and the members' immunity against arrest that are at the center of this dispute are key to our democracy. Without the privilege and immunity, debate in Parliament might be stifled. This would be deleterious to our democracy. The pluralistic nature of our parliamentary system must be given true meaning. Each member of Parliament has a right to full and meaningful participation in and contribution to the parliamentary processes. We can be assured of the best possible legislative outcome only if the parliamentary process admits of the expression of the views of the smallest party, listening to the opinions of the timorous, and being tolerant of the expression of even the most unpopular thought. However, parliamentary free speech is not absolute. The Constitution empowers Parliament to determine and control internal arrangements, proceedings and procedures, and make rules and orders concerning its business. This power facilitates the maintenance of order and discipline. Parliament may do this by various means, including the temporary exclusion of disruptive members from the chamber. The Constitution also provides that the privilege of free speech is subject to Parliament's rules and orders. In terms of the Act, causing or participating in a disturbance is a criminal offence for which members are liable to be arrested in terms of Section 11. Surely, the threat of arrest for a criminal offence with all that may ensue has the potential of inhibiting free speech in Parliament. Based on this, the majority concludes that if person in Section 11 includes members, it does limit the privilege of parliamentary free speech. This limitation is at odds with the constitutional stipulation that free speech may be subject only to Parliament's rules and orders. The question is, does person in Section 11 include members? The majority judgment observes that throughout the Act, person preponderantly includes members. When interpreted both contextually and purposively, person in the section includes members of Parliament. The majority judgment holds that the omission of the words other than a member after the word person in Section 11 is inconsistent with the Constitution. It rectifies the constitutional defect by reading in these words. It dismisses both the appeal and cross-appeal. The concurring judgment by Nugent A.J. agrees with the majority judgment insofar as it emphasizes the importance of free speech in Parliament and that Section 11 of the Act is unconstitutional insofar as it relates to members of Parliament and its committees. The concurring judgment, however, holds that arrest in Section 11 of the Act has a wider meaning to that of the majority judgment. The concurring judgment holds that arrest is not confined to arrest with the object of prosecution and that the mere act of seizure or forcible restraint, which is what occurred in this case, for whatever purpose, constitutes an arrest which is constitutionally impermissible. In a dissenting judgment, Jafta J., in whose judgment Gabinde J. concurs, holds that the word person in Section 11 must be interpreted restrictively to exclude members of Parliament. He concludes that if it is so construed, Section 11 of the Act is consistent with Sections 58.1 and 71.1 of the Constitution. He reaches that conclusion on the application of the reading down principle, which entails that where it is reasonably possible, a statutory provision must be read in a manner that makes it consistent with the Constitution. The following order is made. 1. The declaration of constitutional invalidity of Section 11 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004, made by the High Court of South Africa, Western Cape Division, Cape Town, is not confirmed. The omission of the words, open quote, other than a member, close quote, after the word, open quote, person, close quote, at the beginning of Section 11 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act is declared to be inconsistent with the Constitution. That was 2. 3. Section 11 of the Act is to be read as though the words, open quote, other than a member, close quote, appear after the word, open quote, person, close quote, at the beginning of the section. 4. The appeal is dismissed. 5. The cross appeal is dismissed. 6. The respondents must pay the applicant's costs, including the costs of to counsel. I hand down the judgment.
Court adjourns.
There you have it. The case is dismissed with cost to the applicant. Let's move on now. President Jacob Zuma has dismissed allegations that the Gupta family has influenced the appointment